is our Building Bridges for America Civics 101 presentation. We call it Back to the Basics. And the reason we're going back to the basics is because we want to focus on what's at stake in every election. And if you all have been following Building Bridges for America, you're aware of our mission, our values, and our vision, and that we believe that the economy and our government should work for everyone, and that healthcare is a right, our diversity is our strength, and democracy is worth defending. And some of the tools that we think will be helpful for you will be to get back, to refresh yourself on some of these Civics 101 basics. Please feel free throughout the presentation to post questions and information in the chat. I will try to save some time at the end for question and answers. That will be the first time that you all will be able to speak if you want to. We're going to cover a lot in this hour. So this is the combination of a marathon and a sprint at the same time. But please stay with us because I think this will be helpful information for you. I am a retired lawyer. I spent my legal career in and around government. I worked at the IU University Counsel's Office. I worked at the Legislative Services in Indianapolis. I worked for our governor. And then when I went into the private sector, I was a lobbyist, and I worked with various states on governmental benefits. So I'm someone who really believes that government can work. I'm an optimist, but I think that in order to be effective, we need to keep ourselves informed. On the Building Bridges for America website, there is a downloadable workbook, and also the presentation slides are there. And this session is being recorded, and it will eventually, pretty short order, be on the website as well. So let's talk civics for the next hour. And so what we're going to focus on, it's a short agenda there, but it's a long agenda once we start talking about it. We want to start with our focus on the U.S. Constitution, talk about how federal legislation is passed, talk briefly about elections, and then also talk briefly about state and local government and the structure of state and local government as it relates to these constitutional issues. And our workshop goal is to give you all a refresher on information that will help you be effective in the actions that you take. Relating back to the Building Bridges for America vision, we think we help to safeguard democracy by supporting an informed and engaged electorate. We also strongly believe in our ability as individuals to have an impact. I'm a collector of quotes, and this is one of my favorites from comedian and actress Lily Tomlin, who says, "I used to say that someone should do something about this, and then I realized I am somebody." And we are those somebodies who can do something about this. The reason behind this training on civics, and Ginny and Kaz and I have been doing this for several years, and we came up with the idea for this session because as you look at social media and you listen to people talk, you realize that there are some gaps in some people's understanding of our system of government. And we also know that if we understand our system, we will know where to focus our efforts and how to be effective. And if those of you on the call are a super volunteer or a regular volunteer, just a trusted voice or an engaged citizen, we hope that this information will be helpful for you. So let's start with talking about the US Constitution. And if you're on social media or you're listening to the news or if you're talking to your friends, you will hear people say with such authority that something that's unconstitutional. And not everything could be, but some things are. So let's talk about the basics. Again, we're going to start with the basics and move ourselves forward. So, what can be unconstitutional? And we start here. This is the basics. And we start with a law. Laws are unconstitutional, or the interpretation of a law is unconstitutional, or the way it's implemented is unconstitutional. And then a law is unconstitutional if it violates something in the Constitution. So we have to be able to anchor our concern to something that is in the Constitution. And then who is it who determines constitutionality? Well, it's the courts. It's not pundits. It's not social media. It's the courts and only the courts. So let's start by just looking at our US Constitution. It is short. It's blessedly brief. There are 7 articles, 7 parts, like 7 chapters. And then there are 27 amendments. And the first 3 articles are in that original Constitution back in 1789. The first 3 articles define the structure of our government. The first is Article 1 defines the legislative branch, the lawmaking branch. The second article defines the executive branch. And the third article establishes the judicial branch. And it is the interrelationship of those 3 branches that are the foundation of our government. The next 7, the next 4 bring the total to 7. The next 4 articles talk about how the federal government and the states relate. Article 4 says that states are supposed to honor other states' laws. Article 5 talks about how the Constitution itself is amended. Article 6 is the Supremacy Clause. It says that the Constitution and federal laws take priority over state laws. And Article 7 is how the Constitution was approved. So if we think back to those first 3 articles, that is where we find the concept of checks and balances and how each branch, the legislative branch, the executive branch, the judicial branch, how each branch is checked and balanced by the others. And it is this relationship that makes our country unique, or 250 years. And it is also when we look at this, you figure that a law has to be enacted, executed, and approved by each of these 3 branches. And what we should take away from it is that, first of all, we can choose where we want to focus, where we want to have an impact. But also, as we look at it, we have to realize it's complicated. Our system of government is not supposed to be streamlined. It's not supposed to move fast. It's supposed to be complicated and even difficult to get things done. So we have to work hard. We have to persevere to achieve what we want to achieve. Ketanji Brown Jackson, one of our associate justices, in commenting on this constitutional scheme, said that presidents are not kings, that the design of our government is to prevent tyranny. And she then also talked about just the balance of powers, or the split of powers. And she noted that federalism, which is our form of government, means that powers are split vertically. meaning we have federal government and we have state government, and then we know we have local government. And that at the federal level and also at the state and local level, powers are split horizontally, that balance of powers between legislative, executive, and judicial. And her conclusion is that this separation of powers, both the vertical and the horizontal, is crucial to keep government from becoming too powerful and encroaching on our liberty. That balance of powers is currently being tested. One of the recent quotes from Trump is that he can do anything he wants, but I can't charge $1. And he said this in the context of his tariffs. Just last month in February, the Supreme Court said that Trump's tariffs exceeded his powers. So if we think back to that three-part chart, or the balance of powers, the Supreme Court said that Trump acting without clear authority from the legislative branch meant that he did not have the real authority to regulate commerce by imposing tariffs. The Trump administration said that the International Emergency Economic Powers Act, IEPA, had given him that authority. But the Supreme Court said, no, it wasn't. If in order for the legislative branch to give away one of its core powers, the power of the purse, the power to tax, in order for Congress to have done that, the Congress would have had to be very specific. It would have to be very clear because a major question was involved. And the court found that there had not been a clear delegation. To add just a little bit of context to this idea of a major question was something that the court had used to keep President Biden from implementing his student loan forgiveness and also some of his immigration changes. So this is this question the major question issue is one that is a check and a limit on what presidential authority can be exercised. But just because we have this one ruling on imposing a limit on presidential authority, we should keep worrying. As we know from the 2024 election, we have Project 2025 out there, and from the Heritage Foundation. And the basic premise of that 900-page document is really to dismiss the concept of 3 separate branches of government and give much, much more authority to the president under the unified executive theory. Another reason that we should worry is that there are different groups out there pushing for a constitutional convention. And the Article 5, which if you remember back to one of our earlier slides, Article 5 of the Constitution describes how the Constitution can be amended. And the conservative groups are pushing for a national convention to rewrite the Constitution. And the goal in rewriting it is to change some of the protections of individuals and to give more authority to the president. To initiate such a convention, 2/3 of the state legislatures must approve it. And so far, 28 have taken action. So if you're in a state where someone says, oh, we got to change things, we got to have a constitutional convention, be very worried. Another reason why we should continue to be worried is because of that the Supreme Court granted Trump absolute immunity from criminal prosecutions for actions taken within his constitutional authority. And they went even beyond that and said that even if it's not entirely clear, there should be presumptive immunity from prosecution for his official acts. There would be no immunity for unofficial acts. So even though we have this recent case putting some limits on presidential authority, there is still cause for us to be concerned. But let's talk about some. So that's just happening under those first 7 articles of the Constitution. But we have other parts of the Constitution to worry about or to be aware of, and those are the amendments to the Constitution. So right after the U.S. Constitution was originally adopted, 2 years later, the Bill of Rights was adopted. These are 10 amendments to the Constitution, which are limits on what the federal government can do. And we're aware of these, that the First Amendment protects our core freedoms. The Second Amendment deals with the right to keep and bear arms. The third deals with troops being quartered in homes in peacetime. The fourth says there can be no unreasonable government searches and seizures, that warrants are required to search a person or a person's home and belongings. The Fifth and Sixth and Seventh and Eighth Amendments deal with procedures for criminal and civil prosecutions. The Ninth Amendment says that just because a right hasn't been listed doesn't mean it is denied. And so there is protection of individual rights that are not listed in the Bill of Rights. And the 10th Amendment says that powers not delegated to the federal government are reserved to the states. But there's more. The 12th Amendment establishes the Electoral College. The 13th Amendment abolished slavery. The 14th Amendment, which we're going to talk about a lot, it protects the rights and privileges of citizens. And also it says that laws must provide equal protection and due process. The 14th Amendment takes the federal law protection and the federal rights protection and extends it to state and local government. 15th Amendment establishes voting rights, and the 25th Amendment deals with a situation where the president is unable to perform his duties. When we first presented this program, there was a question in the chat saying, well, what happened to the Equal Rights Amendment? Isn't there a 28th Amendment? And there is a proposed 28th Amendment, the Equal Rights Amendment. And under that Article 5, a constitutional amendment was proposed to establish equal rights for women. And it was adopted by Congress in 1972 with a 7-year deadline for the states to approve it. But only 35 states adopted that within the timeline. Then more recently, 3 more states adopted, but then 5 states rescinded their adoption. So there was a question as to what was the status of the 28th Amendment. In January 2025, President Biden said, the ERA is the law of the land, but the federal archivist has not accepted the ERA, and as such, it technically has not been made part of the Constitution. And at this point, it would take congressional action to either to resolve the 7-year timeline issue or to reinitiate the process. If you need a resource on that, there's one there at the bottom of the slide. But let's talk about something that we know, still out there, something that we need to deal with. And that is the 14th Amendment. The 14th Amendment is a limit on the states and what they can do to limit individual rights. And so we've put on here this slide, just the verbatim what the 14th Amendment says. And the importance of that 14th Amendment over the recent decades cannot be overstated. It's been under the 14th Amendment that marriage equality has been protected by the Supreme Court. The Loving case in 67, protecting interracial marriage, the Obergefell decision in 2015, protecting same-sex marriage. These two cases are an example where we have a fundamental, the Supreme Court recognized the fundamental right to marry, even though it is not specifically mentioned in the Constitution. 14th Amendment has also protected rights for contraception in 1965 and 1972. And the theory of the Supreme Court here was that they were protecting the right to privacy as a fundamental right under the Constitution. And then we come to reproductive rights. And it was under the 14th Amendment that Roe v. Wade was decided, providing a right to abortion. And then in 1992, there was a modification of that in the Casey case. And then, as we know, in 2022, the Supreme Court overturned those prior cases and agreed with a Mississippi ban on abortion after 15 weeks. In that Dobbs case, which is the one that overturned Roe v. Wade, the majority of the court said that that the 14th Amendment does not provide a right to abortion, and under an originalism test, they called it. Originalism meaning that you had to go back to when the Constitution was written, when the amendments were adopted, to find out what was the intent there, and only those rights which could have been identified at that time would be protected. And this is Justice Alito saying, even though the 14th Amendment has been held to guarantee some rights that are not mentioned in the Constitution, such rights must be deeply rooted in the nation's history or implicit in the concept of ordered liberty. And the court found that abortion did not fall within those parameters. And what Alito said was, well, our decision returns the issue of abortion to the states, to the state legislatures. And women are not without electoral political power. So he was challenging us to use our vote to protect abortion in our states. Alito's decision also opens the door for federal legislation banning abortion. Since the Dobbs case, 13 states have total abortion bans, 6 states have very early gestational limits, and 41 states have some form of restriction on abortion. And the originalism history test, as enunciated in Dobbs, would clearly put the rights of historically disenfranchised people at risk in all areas, not just in reproductive cases. And so just as we know, the most important election is always the next election. Lest we think that the 14th Amendment is only about these social rights, these health rights, the 14th Amendment has also been used to extend the Second Amendment guarantees to the state and local level. Starting in 2008, the Supreme Court said that the Second Amendment, operating through the 14th Amendment, guarantees an individual a right to possess firearms, whether they're in the state militia or not, and to use firearms for self-defense in the home. And shortly thereafter, in the McDonald case, Supreme Court said that the Second Amendment definitely applies to state and local governments through the 14th Amendment, meaning that state and local governments cannot put on restrictions of gun ownership in a way that would be determined to not be consistent with the Second Amendment. In the last few years, there's been some very, very important litigation at the Supreme Court level on the Second Amendment. The Supreme Court struck down a 100-year-old law in New York State dealing with concealed firearms. And what the court said, again, under that originalism historical test, is that any regulation of firearms must be consistent with historical principles. After that case in New York, the next case of import in the Second Amendment that the Supreme Court took up was the Rahimi case, dealing with a federal law that denied gun permits to individuals with domestic violence restraining orders. The court did uphold that federal law, saying that the historical principle did not have to be an exact historical twin with what was happening now, that there could be analogy, it could be related by analogy. Just recently, again, I think it may have been at the end of February or very beginning of March, the Supreme Court heard arguments in the Hamani case. And this is a case under federal law which would makes it a felony for an unlawful user of a controlled substance to possess a firearm. So the arguments are out there. We don't know which direction the Supreme Court will take, whether it will have a strict construction or whether it will allow an analogy to historical precedent. So again, based on questions we've had before, what we find is at this point, people are saying, wait, if the Supreme Court isn't deciding things the way we want them to decide things, what can we do? There's, I would say at this point, not a lot, but wait for that, keep working on that next election. The number of justices, 9, is set by Congress. So to make the court bigger, we need congressional action. And as we know, justices are nominated by the president and approved by the Senate. President Biden established a presidential commission which issued a report with recommendations or observations about the court. And there's a brief summary here. One of the thoughts was, if we want to have term limits, well, that's going to take a constitutional amendment. Do we want to have a code of ethics? Is there a way to manage the court's type of cases the court hears? The Supreme Court did adopt a code of conduct, which we've summarized here. There are not any sanctions for violation of the code of conduct. And so what can Congress do? And we talked about, they can change the number of justices. They can institute a constitutional amendment to change the tenure. They can pass legislation to change the jurisdiction and procedures that the court follows. And U.S. judges are subject to impeachment under the impeachment procedures, where the House votes for the impeachment and the Senate is the trial body for that impeachment. And what can we do? We can vote, and we can make sure we elect president who nominates Supreme Court justices and other justices who are good analysts of our Constitution. And we can elect the senators who approve the nominations. And we elect those senators and representatives at the federal and state level who pass legislation to respond to court decisions. And finally, we can support the organizations that litigate these important issues, because We are not going to do that, but organizations are that we can support can do that. So we've talked about the Supreme Court interpreting laws, and we've ended that discussion by saying, well, but now we're going to vote for those senators and representatives who make laws. And this will now refer us back to the workbook that goes along with this presentation. And it has some, I'm not going to go through these, step by step or page by page, but I just want you to know what's in the workbook that you can download. There is the 5 easy steps for how a bill becomes a law, if only it were this easy. But these, in fact, are the steps that bills are drafted and introduced, and they go to committee, and then they're voted on in one chamber, then they go to the other chamber, meaning they go from the House to the Senate, Senate to the House. And then the bill's passed, and it's sent to the president for his approval. And this process, although it's so easy to draft out here, is so hard in reality because of rules. One of the rules that makes it really hard is a Senate rule, which allows a filibuster, which is a delay of action on legislation. And it's really, it's very interesting, I guess, to someone like me, to think back, what was the original idea of the filibuster? It was actually to allow the rank and file to have a vote, to have a voice on legislation. But it has evolved as a way to allow senators to prevent action on legislation, and to keep real debate from occurring. The way that a filibuster is stopped is by a cloture vote. And cloture means to end debate and submit a legislation for vote. And cloture requires 60 votes. So really, in the Senate, even though there's only 100 members, and you think that 51 would be enough, or that it takes 60 senators for anything to move, whether it's a legislation or an amendment or the consideration of an amendment. Now, the filibuster does not apply in all instances. The filibuster does not apply to a reconciliation legislation or to the appointment of judges or an appointment to the cabinet. It's important to note here that the filibuster rule can be changed, can be amended by the Senate. I mentioned that the filibuster does not apply to reconciliation. And reconciliation is any measure, any bill or resolution pertaining to revenue, taxes, and the debt limit, and that can be approved by a simple majority. And then on this page, the bottom here is something that we've included just because it was brought up in one of our very first sessions, is what kind of government are we? And just to remind you, we are a federal government with 3 levels of government. We are representative and we are democratic, and that we are a republic because people choose their elected delegates. And this is from a document of the Congress itself. In the workbook, we just have some reminders of who's who in the House and the Senate, how many senators there are, what are the basic terms of office. And then who's in the House of Representatives? We have 435 representatives, and that number is set by law. And that 435 is apportioned per state. So every state gets at least 1 congressman, and then in order to get more than 1, the allocation of those is based on population. And then once the 435 is broken down and allocated state by state, then the state establishes the districts for those representatives to represent. And so if we look to 2026, every congressman is up for election. 1/3 of the US senators are up for election, 13 Democrats, 20 Republicans. And if you're looking for ratings on these races, like what's the likely Republican, what's the likely Democrat, you might consider the Cook Political Report. And then it's not too early for you to start checking on your senators and representatives or the candidates to as to what are their views on issues that are important to you. And then you can sign up for our course, which is how to be politically active, so that you will get tips on writing to your elected representatives. So let's focus a little bit on those elections, because everyone, if you're hanging out talking to some groups of friends, they're going to tell you, I don't like any of them. I don't want them all. I don't want any of them out there. Well, that's not exactly how elections work. So we have in the workbook a glossary of election terminology for you to refer to. Some of it's pretty basic. Some of it does give you takes you a little farther into the weeds, like what's ranked choice voting. And we have a baker's dozen of terms for you to consider. And a couple of these we're going to talk about in a little bit more detail. One is gerrymandering and one is political action committee. And as we know, gerrymandering is the practice of drawing a political district map in order to increase a particular candidate or party's advantage in a subsequent election. Meaning that whoever's drawing the maps, which is the state legislature, if we're talking about congressional districts, that they will look at who the voters are and they'll try to draw districts so that it basically only one party will have a chance of winning that district. Political action committees are organizations formed to promote an individual's candidacy by raising money and giving that money to the candidate. We have some more terminology there, and then we just talked to some of the real basics here about the administration of elections. States are the primary organizers, administrators of elections. The federal role is very limited. As a matter of fact, we have the 13th Amendment and the 15th Amendments dealing with the rights of citizens after the abolition of slavery. And then we have the Federal Election Commission, which is responsible for campaign finance disclosures. So let's just talk a little bit more about gerrymandering, because again, we've heard from we're from Indiana, so we know how living in a red state can be frustrating. And we both talk to people who say, well, my vote just doesn't matter. Well, it does. Your vote still matters. Because let's just really be factual about this and say that the idea of gerrymandering, it only matters where there are districts, which is be like congressional districts, maybe your state legislature, maybe your local bodies. But if there's no district, if we're talking about a statewide office or a citywide office or a countywide office, they are not subject to gerrymandering. Your vote matters. And in fact, your vote always matters, because you want the races to be close. Even if you're going to lose, you want races to be close so that there's not a mandate resulting from an election. And then let's talk about the Supreme Court and what it has done to us on gerrymandering. There are two kinds of gerrymandering. One is when the gerrymandering is done just purely for political or partisan reasons. And the Supreme Court said, if drawing a district and excluding some people and including others is done solely for partisan or political basis, then those decisions cannot be reviewed, cannot even be challenged in court. And it was this case, this approach, that led the Supreme Court to allow the mid-decade gerrymandering in Texas and in California. And it is what will be considered with the other states that are doing mid-decade redistricting. Now, racial gerrymandering is prohibited under the 14th Amendment, Equal Protection, and the Voting Rights Act. And racial gerrymandering is prohibited if the purpose is to deny the right of any citizen to vote on account of race or color. The Supreme Court's record on this is mixed. In 2023, the Supreme Court held that an Alabama map likely violated the Voting Rights Act by diluting the votes of Black residents. But just a year later, the Supreme Court said, well, yes, racial gerrymandering is bad, but if you can convince us it really isn't racial gerrymandering, if you can convince us it is political gerrymandering, then it's okay. And we think there should be a presumption of good faith, meaning there ought to be a presumption that gerrymandering is done for political purposes and not racial discrimination purposes. So there's some protection there still remaining, but not as much as we might like. And we also want to talk about political action committees from that list of defined terms. As we said, political action committees are fundraising organizations that can give a candidate's campaign donations, and those political action committees are subject to limits. But 16 years ago, the Supreme Court decided the case of Citizens United, and in that case, the court invalidated fundraising and expenditure limitations by corporations and labor unions on independent political organizations, which are now lovingly referred to as super PACs. So if the case is, if an organization says we are independent of a candidate, we are not going to give money directly to a candidate, then the limits on fundraising and expenditure do not apply. And then the 2024 election, these super PACs set a record of spending at least $2.7 billion in those elections. And this is on for Democrats and Republicans. One of the terms you might hear with regard to these super PACs is dark money. And even though there are reporting requirements for super PACs, there are some ways around that where a nonprofit can add their money, give their money to a super PAC and not disclose fully the amount, who their donors are, or the amount that has been given. But we are at a stage now where this is what the Supreme Court has said is the law. So what we would be doing if we want our elected officials to address this is we would probably focus on the dark money aspect, asking them to work on more reporting, more clarity in the reporting, because otherwise we understand is that it would take perhaps a constitutional amendment to undo the ruling in Citizens United. Before we leave this talk about elections and all those definitions, I want to just mention that David Pepper, very helpful, has a very helpful book called A User's Manual for Saving Democracy. And one of his, I think, very important points is that what we need to learn from the MAGA election strategy is that we want to focus not just on federal elections and swing states and districts in federal election years, but we want to pay attention to state elections, state houses, all states, all levels. And this is an area where we can have more impact and where we will be building our bench for the future. So that would mean that you all should become an expert on any upcoming elections in your state. Who's on the ballot? What is the last day to register to vote? What's the last day to request a mail-in ballot? What's the first day of early voting? When do polls open and close? And how can you get out the vote? So we're going to sail through this last part here because we're going to be talking about state government, and with there being, 50 states, each state government is going to be the same in many ways, the federal government, but different. And so what is in the workbook is some basic information about about each state, but I focused on my home state of Indiana, how the branches of government are broken down, what's the current breakdown of Republicans and Democrats. What is how the redistricting is going. And I'm very, very proud of our state of Indiana because they rejected a call for redistricting. And then learn how a bill becomes a law. And this is how it's done in Indiana. I hope you all can track how it's done in your state, and how the executive branch and the judicial branch are organized. We're just going to close out here with, who's in charge, the state or feds, when it comes to certain topics. The states still have a lot of authority over property ownership, justice system, elections, insurance. And the homework for all of you, should you choose to do it, is just to prepare a chart of the structure and the offices in your state and what are their positions on issues that are important to you. There is another handbook for our the session we just had last week, but it has a chart for you to use to fill out this information. And then this is where you use that knowledge when you're canvassing, if you're a poll worker, and I'm getting ready to work the polls in Indiana in about 6 weeks here. And just be a resource in your network. Some places for you to go to keep track of what's going on at the Supreme Court. My go-to place is the Supreme Court blog, SCOTUS blog, League of Women Voters, to find out who and what are on the ballot. If you're tracking legislation, Legiscan. And I'm a real fan of the Brennan Center for anything dealing with voting, elections, democracy.